Well, good afternoon, everyone. Thank you for coming to our webinar today. I am Jason Broughton, Director of the National Library Service for the Blind and Print Disabled here at the Library of Congress. The National Library Service, known as NLS, is a free Braille and talking book library service for people with temporary or permanent low vision, blindness, or physical, perceptual, or reading disability that prevents them from using regular print materials. Our vision is simple, that all may read. Today, you will hear from our speakers who will discuss human rights, accessibility, and even a little bit of disability rights within our country and across the world. I want to thank my colleagues at U.S. Copyright Office, the Law Library of Congress, and the Library of Congress's John W. Klug Center for Kluge for creating this important conversation. I also thank Representative Debbie Dingell for being here and our senior law specialist from the Law Library. When our speakers discuss human rights and accessibility, we hope this will inspire and even empower individuals and communities to forge a better tomorrow for the betterment of all mankind. By embracing and trusting the full power of human rights as a path to the world we want, we can become a more peaceful, equitable, and sustainable, in a sense, planet that we live upon. And looking at dates, December 10th is the normal day in which Human Rights Day is celebrated across the world, in which its discussions are pathways to solutions, playing a critical role as a preventative and protective and transformative force for good. And also, I'd not be remiss if I didn't mention that December 3rd was International Day of Persons with Disabilities. Countries across the world recognize this day to promote awareness and support the dignity, rights, and well-being of persons with disabilities. In closing, in our existence, it is my belief as human beings of this planet called Earth, I believe we can say that accessibility in its past, present forms, and forms to be yet discovered will play an important and pivotal role in making sure that we even have access to the enjoyment of rights. Within that, the enjoyment of rights requires the possibility of access, and its absence may imply a range of things that can appear to be as a barrier or even discrimination. With that, I now introduce to you our moderator. Dr. Kevin Butterfield, the director of the John W. Kluge Center at the Library of Congress, will be our main moderator. Dr. Butterfield is a historian of the post-revolutionary United States. He most recently served as executive director of the Fred W. Smith National Library for the Study of George Washington at Mount Vernon. Dr. Butterfield earned a BA in History from the University of Missouri and an MA in History from the College of William and Mary, and a PhD in History from Washington University in St. Louis. I bring before you my wonderful colleague, Dr. Kevin Butterfield, to be our moderator.
Thank you, Jason. Welcome everyone to this panel discussion on the laws governing accessibility, which we will, over the next hour or so, put into as broad a context as possible in a couple of ways. We want to look both domestically and globally at laws relating to disability and accessibility. And we want to explore these questions with an eye not just to best practices, but to human rights. This is obviously in connection with the observed anniversary of the 1948 adoption of a Universal Declaration of Human Rights. And I'm excited to dive into these topics with our distinguished panel and with all of you. Our first speaker will be Congresswoman Debbie Dingell from the 6th District of Michigan, who, in addition to her many important roles in the U.S. House of Representatives, also serves as co-chair of the Bipartisan Disabilities Caucus, where she works across the aisle and with colleagues in the Senate on important issues such as the ones we're discussing today. Second, we'll hear from Andrew Foglia, the Deputy Director of the Copyright Office of Policy and International Affairs, a division that provides support and technical advice to Congress and represents the Copyright Office at meetings of government officials concerned with the international aspects of copyright protection and enforcement. And third, Elin Hofferberg is Senior Foreign Law Specialist at the Law Library of Congress. Elin came to the Law Library in 2011, regularly conducts research and prepares written reports on the laws of the Nordic countries, European Union, international law, for members of Congress, government agencies, and the public. Representative Dingell, thank you so much for being here, and I'd like to give you the floor to ask you to share with us your view of disability rights in the United States today, the legal framework that prevails, and where you see these things going in the future. What can you share with us?
So thank you, and it's great to be with all of you, and thank you for inviting me to be with you for Human Rights Day to talk about an issue that really matters to me and is close to my heart. And quite frankly, is the focus of a lot of the work that I do in Congress. Being co-chair of the Bipartisan Disabilities Caucus with Representative Brian Fitzpatrick, a Republican from Pennsylvania, is one of the positions that I hold in Congress that I take the most seriously and I'm the most proud of, because the work is so important. One thing that I have learned is that not enough of my colleagues in Congress and not enough people in general understand the importance of this work or how much still must be done to advocate for individuals with disabilities. It's hard to believe this, and I watched it when it was being considered and passed. The landmark Americans with Disabilities Act was passed 34 years ago. The ADA has been tremendously successful in providing millions of individuals with a better quality of life, to other initiatives to empower people with disabilities to fully participate in American life. It's helped remove barriers to access to employment, transportation, communications, recreation, and more. And what's important is that we've continued to make quick progress since the passage of ADA. But what I always tell everybody is we have a lot more to do. Disability rights are civil rights. And it's my mission to make sure every member of Congress, that everyone who has a position of being able to impact and influence understands the importance of this work. And importantly, this work has historically been and continues to be bipartisan, because these issues are issues that affect everyone, regardless of party. Good, sound policy is created when everyone has a seat at the table. I've always worked on this issue, but it became very personal to me when I was helping to take care of someone who was an avid outdoorsman, spent his entire life outside hunting, fishing, running. And as he got older, began to develop serious arthritis that gave him mobility problems. His brain was as sharp as a tack to the minute he died. But living with him, seeing his frustration, dealing with a lot of the different issues gave me a better understanding of just how far we still must go to ensure that Americans with disabilities are not excluded or left behind. So let me talk just for a few minutes about some areas that I'm specifically working on to expand protections and support for Americans living with disabilities. One of these areas is strengthening long-term services and support in the home and community, or HCBS. People should be able to stay in their own homes in the settings of their choice when they're living with disabilities or facing issues that are just because they're aging, but still are totally participating in life. I've then introduced several pieces of legislation that would increase federal funding for home care, invest in our caregiving workforce, and make it easier for people who need care to get up without having to spend years on a wait list. Right now, more than 1 million people are on that wait list for HCBS. The Better Care, Better Jobs Act would enhance Medicaid funding for home care, helping many of the 650,000 people on waiting lists nationally finally receive care in the setting of their choice, allowing them to stay active in their communities and live independently. This legislation would strengthen the caregiving workforce, improve quality of life for families, and boost the economy by creating good paying jobs to make it possible for families and workers alike to thrive economically. This bill would also permanently authorize protection against impoverishment for individuals whose spouses receive Medicaid, home and health care, HCBS, as well as Money Follows the Person program to support individuals transitioning from institutions to home or community-based settings. Many of you, if you're living with this, know that in order to qualify for Medicaid, traditionally, the spouse or you have to get rid of all of your assets. That's not right for a spouse. And I've been working very hard to make permanent the spousal impoverishment provision so that spouses don't have to do that. Another piece of legislation I've been leading is the HCBS Access Act, which would make HCBS a mandatory benefit with Medicaid. It would increase Medicaid funding for home and community-based services. It would provide grant funding for states to expand their capacity to meet the needs of people who want to stay in their own home in the community of their choice. Take steps to improve the stability, the availability, and the quality of direct care providers. Provide states with resources so that caregiving workers have stable, quality jobs and a living wage. Provide training and support for family caregivers. And it would also create better evaluation measures to assess the quality of HCBS being provided. We need to modernize Medicare reimbursement. This would do that. And it would also increase patient access for home-based health services. It would remove barriers currently limiting patient access to care in the home, which is so often the preferred site of care for patients, caregivers, and the providers. It's where people want to be, and ensure that home-based care is a viable option for patient care and scalable for providers. The other thing that this bill would do is provide much needed support to state programs that fund home and community-based long-term care services, with dedicated Medicaid funds for states for 2 years to stabilize their HCBS service delivery networks and recruit and retain direct care workers. Meet the long-term service and support needs of people that are eligible for Medicaid. This is so important to so many people with disabilities. They want to stay in their community. They want to thrive, and they just need a little support. And we need to be providing this. It's just something we should be doing. We also need to continue to support investments in affordable, accessible housing. It's a real crisis in this country, and connecting Americans with disabilities to these resources. Earlier today, I spoke at the National Housing Conference convening on affordable housing and discussed some of the challenges individuals with disabilities have finding safe, secure, and affordable housing. People just don't think about it. They don't know how hard it is sometimes. We also have to support inclusivity in the workplace and strengthen opportunities for employment for people with disabilities, and guarantee that employees with disabilities have their workplace rights respected. Collectively, these policies will advance equity and remove barriers for Americans with disabilities who deserve access to all the same spaces, opportunities, information, and resources as their peers. So I want to thank you all for including me on this important day, letting me share with you what are some very important priorities for me. And I promise you, I will continue to work on these in Congress and continue to work with partners, including those who are here today, to advance disability rights. Thank you.
Thank you, Representative Dingell, for your time. We really appreciate your joining us today.
Thank you.
Let me bring things to Andrew Foglia from the U.S. Copyright Office. Andrew, I believe you prepared a presentation that might help us understand where copyright law informs accessibility, both domestically and internationally. Let me hand things over to you.
Thanks, Kevin. So by way of background, copyright protects original works of authorship. Next slide, please. The way it protects them is by giving the owner certain exclusive rights. Those exclusive rights include, importantly, the right to make copies, the right to perform a work in public, the right to prepare derivative works, including translations. Because of that, things like translating a book into Braille, or adding closed captioning to a movie, or making accessible format works generally, implicate copyright law. That means in order to make accessible format works, you typically need a copyright exception. Next slide, please. In US copyright law, we have a few key exceptions for accessibility. 17 USC section 121, sometimes called the Chaffee Amendment, allows for qualified nonprofit organizations and government entities to make and distribute accessible format copies of published literary works for use by blind persons or persons with other print disabilities. One of the main providers under this section is actually NLS. They provide about 2 million copies of Braille and audiobook copies each year. Another section is section 17 USC 110(8). Under this section, an authorized entity can perform non-dramatic literary works, I mean not plays, by transmission specifically designed for persons with visual or hearing impairments. They have to do so for no direct or indirect commercial advantage. Then there's fair use, which is a flexible exception in US copyright law. The Supreme Court has said that making copies for the convenience of a blind person is a fair use. They say that because Congress has said it repeatedly in the legislative history of the 1976 Copyright Act. I'll quote here from Congress, quote, "The making of a single copy or phonorecord by an individual as a free service for a blind person would properly be considered a fair use." Now that's a single copy as a free service, but you might have a question about other kinds of disability services, or if you wanted to make accessible copies in a commercial context. For that, you might have to fight it out in court on fair use. People have often said fair use is a right to go to court. For example, there was a case, Authors Guild v. Hathitrust, where Hathitrust had made its digital library collection available to print-disabled persons, to students rather. And they had to go to court to defend them. They were successful. It did take time and money. Next slide. Another part of copyright law that affects access is Section 1201. Section 1201 concerns technological protective measures, or digital locks that control access to copyrighted works. It is a violation of copyright law to break those locks or to traffic in devices that break those locks, even if what you're doing afterward would be lawful. So let's say that I have a physical disability and I use a specialized input device for controlling my phone. But the only way to make that input device compatible with my phone, for example, is first to jailbreak the phone. That is a problem, and I would need an exemption for 1201 to do it. Now, Congress provided a way to get temporary exemptions from 1201. It's a rulemaking process that the Copyright Office and the librarian engage in every 3 years. And under that process, the librarian has repeatedly granted an exemption for motion pictures, for adding captioning and or audio description by disability services in schools or similar units for the benefit of students or faculty or staff with disabilities. Similarly, they have repeatedly granted an exemption for literary works for breaking access controls that interfere with the use of assistive technologies like screen readers. The challenge is that these exemptions have to be pretty specific, and you have to petition to renew them every 3 years. In 2021, for example, and some accessibility advocates proposed or petitioned for a general exemption that would allow that would apply to all works for accessibility purposes. And unfortunately, the statute does not give the librarian access to adopt an exemption for all works. The exemptions have to be on a class-by-class basis for particular kinds of works, and we need evidence for each of those specific kinds of works. So with this request for general exemption, when the petition was boiled down, the Copyright Office found there was only evidence for an exemption specifically for input devices for video games. And that petition was not renewed 3 years later, so it lapsed, even though I think both the advocates and the office agreed it was still a meritorious exemption. At the time, the office recommended that Congress adopt a permanent general exemption. I'll quote from our recommendation here. Quote, "Generally, public policy favors removing impediments to access for individuals with disabilities. Accessibility is not merely a matter of convenience, but it ensures that individuals with disabilities have meaningful access to the same content that individuals without such impairments are able to perceive. For individuals with disabilities, proposed exemptions may represent the difference between having and not having access to the works available to others. For these reasons, the office has recommended that Congress enact a permanent exemption for accessibility into law. Now, that's the domestic side. I'll talk now about the international measure. Next slide, please. The major instrument here is the Marrakesh Treaty. The Marrakesh Treaty arose out of a widespread recognition of what was called a book famine, a dearth of books published in accessible formats. Producing accessible format books can be time-consuming and costly. The result is that less than 10% of the world's published materials can be read by visually impaired persons. Fewer than 60 of 186 WIPO member states had national law exceptions for accessible format copies. And even when they could make them under their national law, most national legislation did not allow cross-border sharing of those accessible format copies. Next slide. Sorry, next slide, please. The Marrakesh Treaty, what it does is it requires countries to provide an exception in their copyright laws to make it easier for blind and print-disabled persons to obtain printed works in accessible copies, such as Braille or digital audio files. It also establishes rules enabling cross-border exchanges of those copies. The beneficiaries include the blind, persons who are blind, visually impaired, print-disabled, or otherwise have a physical disability that prohibits them from holding or manipulating a book. Now, under this treaty, certain authorized entities, including government entities or entities recognized by the government, can make these accessible format copies, and they can facilitate cross-border exchanges. There are 3 conditions. Well, 4 conditions, really. First, they have to be authorized. Second, they must have lawful access to the work in the first instance. Third, they can introduce only those changes that are necessary to make the work accessible. And fourth, they can supply copies only to the beneficiaries of the treaty. The US is a Marrakesh signatory. We passed the Marrakesh Treaty Implementation Act in 2018, and that included updates to our existing copyright exceptions. I think you may hear a little bit more about Marrakesh implementation later on. Now, what about exceptions that fall outside of Marrakesh? Next slide, please. Well, first, as you might hear later, there is the UN Convention on Rights of Persons with Disabilities. And second, more generally, international copyright treaties contain what is called the 3-step test for domestic copyright exceptions. That is, domestic copyright exceptions are allowed in special cases that do not conflict with the normal exploitation of the work and do not unreasonably prejudice the legitimate interests of the author. So in theory, if a country introduces a new exception beyond what is provided in Marrakesh, it needs to comply with that test. With that, I will turn it back to Kevin and our next panelist. Thank you.
Thank you, Andrew. We're now going to turn to Elin Hufferberg, a senior foreign law specialist in the Law Library of Congress. Elin, we've asked you to describe the Law Library's research into foreign and international law as it relates to disability and accessibility to information. Can you describe the research that you've done and what you've learned in your work at the Law Library?
Thank you, Kevin. So first, a little short background on the Law Library of Congress. So we have a division devoted specifically to foreign, comparative, and international law, known as FCIL. You could think of it as a mini UN with foreign legal specialists and analysts, essentially lawyers trained abroad and in the US with native language and foreign law expertise. We research foreign and international law, primarily for the benefit of Congress, but also for the government agencies and the judiciary, and provide research assistance to private citizens. That research is then compiled either as a single jurisdiction report or a multinational report. And then we provide a publication known as the Global Legal Monitor, where we publish articles on recent legal developments on individual jurisdictions. In relation to the rights of persons with disabilities, we have produced a multinational report called Access to Information for Persons with Disabilities, where we look specifically at how persons with disabilities are protected on the international, regional, and domestic level with respect to the access to information. And I see Robert has already put on the first slide. In total, we surveyed 27 jurisdictions, all of which have ratified the United Nations Convention on Rights of Persons with Disabilities. Or as in the case of Taiwan, which is one of the jurisdictions covered, it had incorporated a convention in its domestic legislation. We surveyed mostly jurisdictions that had ratified the Marrakesh Treaty, but also a few jurisdictions that hadn't, for example, Egypt. And if you look at the second slide, you will see that we looked as a first step in conducting that research, whether or not each jurisdiction protected persons with disabilities in their constitution, right? So if their constitution explicitly mentions persons with disabilities. Now, the rights explicitly mentioned are not the same rights in every jurisdiction. For example, not all jurisdictions explicitly mention that persons with disabilities have a right to information, but it could range from more general rights to specific rights tied to social support, education, and right to representation in the legislative body, for instance. What we also noticed was that several jurisdictions that did not explicitly mention disabilities in the Constitution still had a catch-all provision that would tie in the UN Convention on Rights of Persons with Disabilities. For example, Norway has a catch-all provision, which refers to its international obligations. And there, the Convention on Rights of Persons with Disability applies, the European Convention on Human Rights applies, but also international law generally, right? So it really does protect persons with disabilities in its constitution, although it doesn't say so explicitly. And then you could also find some jurisdictions that, while they did explicitly mention persons with disabilities, that right or those protections were not actually justiciable in court. For example, in India, the constitution includes directives of state policy that includes rights for persons with disabilities, but these directives must be realized over time and cannot be forced as a right in court. And those enforceable rights for other countries, not specifically for India, but the rights that are justiciable would be found in piecemeal statutes, right? So you have anti-discrimination laws that you can take to court, you have building code legislation, TV broadcasting regulations and rules. So it's interesting to see how that kind of pans out. That you have to read the Constitution together with statutes and to get it educated. Next slide, please. So as you can see from this slide, most of the countries we looked at have implemented the Marrakesh Treaty ratification, has ratified the Marrakesh Treaty. And as you can see, they also, most of them have something similar to our NLS library, right? And when they implemented it, it was usually incorporated either as a standalone act, just, Marrakesh Treaty copied verbatim, or the specific provisions were put into the Copyright Act in each individual jurisdiction. And one feature of realizing the access to these accessibility format copies that Andrew mentioned before is providing this NLS style service library that the map shows, meaning a service tied to a library that is directly specifically to person with visual and print disabilities. And from the countries that we surveyed, almost every jurisdiction had some kind of NLS style service. Now, not everyone was funded directly by the government, but it could also be funded by NGOs and charities in those cases where there was no public funding for it. But what they did was that they made accessible a whole range of different services. Could you do the next slide for me, Robert? 2 slides over. And this would include Braille and audio services, they would include accessibility formats, transcription services. Some jurisdiction had read alouds where you were allowed to come in if you were a patron. Notably, in all these countries, you would have to qualify for the service in some way or another to demonstrate that you had a disability that meant that you could not, access a book or a recording or something else that was in the purview of the library without getting an accessibility card. But so that with transcription services, translation services, read out loud, text to speech, but it was also an access to through Accessible Books Consortium. So that, and I think that this is where we go back to what made Marrakesh so important, is that it expanded the services that a lot of these libraries had. For instance, some of the European jurisdictions, they had a lot of European books in European languages, but the access to anything that was in English was not covered, right? So it enhanced, if you're sitting in Germany, it's easier for you to read a Swedish book than it was prior, or you could read, and you're sitting in Norway, your library is now paying for the Bookshare app, which is a US app where you can access materials in English. So there's a lot of those things that they were already perhaps happening in many of the jurisdictions that we surveyed, but it helped to facilitate and improve the services that they were offering, that they were the resource material, so to speak, the copyrighted material provided grew. Next slide, please. So from our research, most of the jurisdiction publicly funded the print disabled service, which included blind, sight disabilities, but also in some cases dyslexia and disabilities where the person cannot hold a book. And this, if you go back one slide, go back 2 slides, you can see, again, this is the map of where all those, you can still access them even if they're not all publicly funded. But then not having been designated a library does not necessarily mean that the service is not provided. That's what I mentioned, right? It could be so that in certain countries, even though they don't have a designated library and they don't have a backup, so to speak, in a charity, there might be actually saying that all libraries, for example, in Israel, they have a much wider or broader mandate that each library has to provide the same service. So it's not just one specific library that provides that service. And then also you could, based on our information, that it's not only a right to information through the NLS, but we also saw that it was a lot of rights for services outside of NLS, so that these were generally provided in specific statutes saying that you had right to adaptation tools from all public entities, or that you had right to sign language translations in Parliament or during a court hearing, that you had a right to receive document in a format that you could easily produce it from text to speech, and those are the things that you could see that it's not only providing access through NLS, but you have to look kind of deeper in each piecemeal legislation to find what the rights really are. I think I'm going to stop there.
Elin, thank you. This is obviously a lot to take in because we're dealing with the entire world now, not just our own domestic policy. Because of the 1948 anniversary that brings us to celebrate a Human Rights Day, which is the the anniversary of the Universal Declaration of Human Rights. Can you talk to us a little bit about the United Nations and what role the UN may play in any of this, particularly accessibility?
Yes, absolutely. As you can imagine, the United Nations have several initiatives related to disabilities. And specifically in our research, we found that the United Nations Convention on the Rights of the Persons, the CRPD, with disabilities was and continues to be a driver for change. Individuals, jurisdictions have tasked public and independent bodies to monitor compliance and implementation of the CRPD. And through the UN reports and initiatives, representatives from member states may suggest approaches that the monitored jurisdiction should undertake. And there you could almost call it a peer review between states. For example, several jurisdictions have voiced their opinion that the Norway should adopt the optional protocol, which it has not yet done, but you can see that that creates a movement within Norway that there's a push to do so. You could also see that the European Union has adopted strategies and policy frameworks specifically designated to implement and further the rights in the CRPD. And then to kind of, I guess, to fully realize all of the rights that are in the CRPD, you could even claim that the new 2030 Agenda for Sustainable Development kind of interconnects with the CRPD and makes it something very tangible for member states who signed on to the 2030 Agenda for Sustainable Development and those goals. For instance, Goal 4 of the SPD addresses issues regarding access to education for persons with disability. Goal 8 targets full access to the labor market for persons with disability. Goal 10 addresses the social, economic, and political inclusion. Goal 11 addresses accessibility of transport systems, including explicitly for persons with disabilities, and then also green spaces. So all of those and a lot of countries have adopted, at least from those jurisdictions that we looked at. Granted, it's only 27 jurisdictions and the world is very big, right? But there were several that had provided websites or frameworks or some kind of accountability measure where you could see and track progress as they work to kind of find the best practice of realizing those goals within their own country, but also through, aid or foreign cooperation and things like that. So the UN certainly puts, I think it makes states a little bit aware that they need to work on this issue.
Yeah, it stands out from what you're describing that accountability, best practices, just awareness is clearly a part of the international picture regarding these questions. But some of that might also, some of that is easily described as being cooperative, but it's also just about accountability and in some ways kind of a bit of pressure to pursue the best practices. Can you talk to me about, and maybe Andrew might have something to add here too, about opportunities for international cooperation? The Marrakesh Treaty is clearly a signal example of this, but are there other opportunities for international cooperation in these areas of disability and accessibility that haven't been pursued well or that have been overlooked up till now?
Well, another issue that they're looking at is the web content accessibility guidelines, right? So it's kind of, you have to meet people with disabilities where they are. Maybe 100 years ago, that was reading a book. Today, most of us, if you talk to young people, they don't read books. They don't go, they have all their information, right, online. And then that's where you need to meet them. And I know the United Nations have themselves adopted the web content accessibility guidelines. And the European Union, for instance, are working with this issue too, and specifically have, they have to write a little sentence on each website saying how they're working with accessibility and how well they're living up to it. I looked at one for the Norwegian Parliament, which is not an EU member state, but an EEA state, that specifically said we're not meeting the obligations. This webpage for the Parliament is not, and it had listed all the issues that, why it was not accessible to everybody. And I think that is one of those where it could be easier internationally to both pressure and accountability. And the same goes for any other kind of technology, apps and things like that.
Andrew, any thoughts on this question?
Yeah, I had two thoughts. First, with respect to Marrakesh itself, while a very large number of countries have signed Marrakesh, I think over 120 at this point, there are gaps in implementation, significant gaps in implementation. So there's still room to grow within the Marrakesh framework. Second, looking beyond Marrakesh, a lot of the framework existing exceptions in both domestic and international law are quite focused on print disabilities and sometimes on auditory disabilities. But there are other kinds of disabilities and access questions that are important ones, sort of cognitive disabilities, neurodivergence issues with regard to sensory processing. For example, making copies where you can adjust particular sounds that are difficult for some people to process, or flashing light that might be issues for persons with epilepsy. I mentioned earlier input devices for interacting with phones or consoles or other kinds of hardware. And those are issues that have traditionally not had the same emphasis in accessibility exceptions. I think that's an area for growth in the future.
Sorry, just to piggyback on what Andrew just mentioned, because that's actually one of the things that we saw when we looked at pending legislation in individual countries, was that you could see disability legislation that was specific to one disability. Like autism is something that has perhaps before not been addressed legally as much. And you could see there's a big push like that. And just like you said, the neurodivergencies are also specifically mentioned, ALS specifically mentioned. So there's some of those different disabilities that jurisdictions are working on their own. But to Andrew's point, I think there could be a lot more going on globally and internationally on those issues.
One of the questions that you touched on, Elin, was the web content accessibility guidelines. And there's an audience member asked about this. Are we moving in the direction, this is from the question online, are we moving in the direction of confirming WCAG as best practice for legal compliance? And she also asks, or she, I'm not sure, is there another alternative in place for WCAG? Elin?
I think internationally, it seems like we're moving. I don't speak to US law on this issue, but from the research we did for the specific report for those 25 or 27 jurisdictions, yes, that is what they are kind of looking at. Yes.
I want to ask about this. We were speaking internationally as well as domestically, and when we have seen dramatic change, let's leave aside the Marrakesh Treaty in particular, but how does change tend to happen when we're dealing with some of these questions? Some of what Andrew presented, for instance, described it's the librarian making special decisions here and there to help sort of move things forward. I'm curious, how do we see progress or change happening in countries that start addressing these accessibility questions? Where does the impetus tend to come from? Is it new legislation, other solutions? Where do we see change happening? Elin, I think this is for you.
Thanks, Kevin. It's nice of you to direct the question. So it's interesting, right? There's so many different levels where legislation can really hit the road in different countries, right? You have the Constitution. We have several of the countries we looked at. They're amending their Constitution not only to put in disabilities in the first place, but maybe also to specify or, you know, make broader the actual protections to make them more explicit. And then you have, you know, charities or interest organizations. So it's kind of I feel like they're coming from both sides. And I find that very interesting because sometimes when you put it in the Constitution, that doesn't mean it actually happens, right? You can see that the most effective things is what's happening on the ground. And you can see that, okay, if they're starting to provide this service, that's more meaningful than maybe perhaps, as a lawyer, maybe I shouldn't say that, but how it works in practice is more meaningful than what the law says, right? So, but a lot comes from the UN, a lot comes from regional legislation, a push between countries. But it's also piecemeal legislation, right? So there's maybe just one discrimination act, and then there's just one specific legislation that says something about buildings or something about law. So it's from what we found, it was hard to say that across the board, this is how change happens. It seems to be very jurisdiction dependent.
I actually wanted to say, I like Elon's point about the change coming from multiple directions, because that's something of what we see as well in the copyright space that I know you mentioned outside of Marrakesh, but just taking Marrakesh as an example, some of the countries that were initial proponents of Marrakesh didn't have these domestic exceptions before Marrakesh. They wanted the treaty in a way to help push their national legislature toward these accessibility requirements. And so you see countries, again, it comes both from advocates within the country, within their cultural ministries, within their libraries, and going up to the international level and then coming back to the domestic level. That's not always the case, but it is sometimes the case. And also, like, again, it continues to be a very popular treaty in many ways. And we see, I think, 400 countries this year joined. We're seeing a number of member states joining Marrakesh before other copyright treaties.
Let me ask us in our sort of some closing time here, but I do have a couple more questions for you to think about the future, not so much of what we see right now, but a little bit of projection about what we may be seeing in the near to medium term. Andrew, I'll start with you. Do you see anything pending, any sort of new developments? And we'll come back to technological advancements because I want to set that aside. But is there anything pending that you'd like to mention that you're seeing either domestically or from around the world in the area of copyright, accessibility, and disability? And Elon, I'll throw the same question to you. Is there anything pending in particular jurisdictions that stands out to you as a new direction?
So internationally, I'm afraid I don't have, and I can't think of anything specific coming to mind. Most of the development still tends to be more and more countries joining Marrakesh or implementing Marrakesh. Domestically, well, we just had the recent 1201 rulemaking process. I mentioned the triennial process, and the most recent one came out just last month. So that renewed a number of exemptions for accessibility. And while there wasn't, I don't think there was a new category for accessibility, mostly renewing the old ones. The office, as I mentioned, continues to recommend that there should be a general exemption for accessibility.
Elon, what do you see pending around the world?
Well, I go back to those laws that I mentioned before on web access applications. You see that a lot. But something that is different that I saw in a fewer jurisdictions is reserved seats in Parliament or in other legislative bodies specifically for persons with disabilities. And that's a way of, because you see, I mean, technically often you see it in specific government agencies where they're part of the education or the cultural or something tied to these libraries. But there were a few instances where you see that they were specifically tied to the parliaments. And I think that was interesting because that would create a different dynamic in those parliaments. You know, when you have by law, you have to have representation by legislators. How that works out in practice, I can't speak to that, but that was something that kind of stood out to me.
Well, it's 2024, so we can't possibly have a conversation that doesn't talk about AI in some form or another because we need to, and we need to think through this. Are there elements in new technology, generative artificial intelligence, that you think may be transformative or overhyped? Talk to me about where AI fits into some of the opportunities for accessibility, some of the challenges that we face. Elin, you're still unmuted, so why don't I
I'm
start?
still unmuted. That's what happens when you don't use the technology. You get on the spot. Well, I mean, there are some pros, right? You have alt text, text to speech, reader optical character recognition software, things like that that should make it easier to get, closed captioning or to make, the internet more accessible to us. But then you also have, and I've been reading up on this a little bit, you have the kind of, I don't know, I don't want to call it innate because I don't think AI is innate, but you have these lingering problems of biases, right, in artificial intelligence. And studies seem to show that they also affect persons with disabilities, especially for problems like in the labor market, people are weeded out before they get an interview and stuff like that. So there seems like to be a two-edged sword, right? It could be really helpful on certain issues, but it could also be detrimental. And then there's this push on how much we're using technology that might also, for a person then who's not able to use technology, would make it more difficult for that person to participate.
Andrew, this is my last question for the room. So your thoughts on this question of artificial intelligence and other technological frontiers?
Yeah, so there are two ways that come to mind that accessibility shows up in the generative AI space and copyright. So among the hot topics in AI and copyright is what we call sort of the authorship issue. That is, when can you copyright the output of a generative AI system? And we published a notice of inquiry on AI and copyright last year. And we did ask a set of questions about this. And one of the things we heard from the 10,000 public comments we received was some concern that taking a too restrictive review of when you might be able to copyright the output of an AI system might affect persons who are using these generative AI systems to create in ways they wouldn't otherwise be able to because of physical or cognitive impairments. Of course, the question from our point of view for all users, regardless of whether they have physical disabilities or disabilities or not, is whether the work is essentially one of human authorship, or whether with the computer being sort of an assisting instrument, or whether it is in fact the computer doing the conception and the execution. Separate from that question, we did a report in July on digital replicas. It's not AI specific, although AI is sort of the genesis of that report and the cause of it. That is, these are sort of what you might call deepfakes, digital images that are sound that has been manipulated or created, and that's close to indistinguishable from the real thing. And while there's been a lot of focus on the harms that can come from digital replicas, including labor displacement, fraud, and blackmail in some cases, pornography, all kinds of harms. One of the benefits that many stakeholders point out to us is that there are cases where, for example, performers are able to use generative artificial intelligence to create, essentially recreate their own performing voices in a way that wouldn't have been possible otherwise. So those are two different ways in which you can come up in the intellectual property space.
Well, I want to thank both of you and also Representative Dingell, who had to leave us earlier, for these contributions to this still evolving, transforming set of issues. To bring things to a close, I'd like to hand things off to the Law Librarian of Congress, Aslihan Bulut. And thank you so much, Elin and Andrew. Really appreciate this.
Thank you so much, Kevin. Good afternoon, everyone. I'm Aslihan Bulut. I have the privilege and honor of serving as the Law Librarian of Congress. Thank you so much to our distinguished panel for this fascinating discussion on laws governing accessibility from around the world. I want to thank you all for joining us today to celebrate Human Rights Day. Please visit us at loc.gov/events to learn about future events from the John W. Kluge Center, the Copyright Office, the National Library Service for the Blind and Print Disabled, and the Law Library of Congress. And have a wonderful rest of your day. Thanks, everybody.